a person override the copyright issues. And of course, again, clarity and authorities, we relied on them. The judge also went on to say you can transfer, assign, or license your image rights. And one such a case was Proline. The players in the Proline case, the 11 players had assigned their rights to Proline to represent them. And Proline was the one battling in court on their behalf. Because an issue also came up on the locus standard of Proline and cause of action. And he resolved it very well. Resolved it very well, in my view, and saying, no, the player has a right to assign, and based on the Rooney case and so forth. So that was also clarified. Of course, then the issue was remedies. Remedies, because I am taking a bit of time on image rights because we don't have a law, defined law, where we can, it is this case that is really trying to lay down a number of things for us. So what remedies parties are entitled to and so forth. And the judge, in his conclusion, of course, I just got the final bit of it. The judge, in his conclusion, simply said the judgment is entered in favor of the plaintiffs and awarded general damages of 570 million, which constituted the 5 years breach, because the initial contract was about 114 or so million. So he gave that as general damages and so forth. And then he awarded interest, as you can see, on a 6% and so forth. But also, most importantly for counsel, was the costs awarded. Yeah, and now to go back to the last part a bit, of course, the copyright issues. We have a law guiding it, and in this country, and we have the William Kakoma Attorney General case as one of the leading cases in that area, and it sets the definition for copyright as a set of exclusive rights granted to an author or creator of an original work, including the right to copy, distribute, and adopt, and so forth. So when you look at, in a litigation, looking at the issues of litigation of copyright, definitely you have the Copyright and Enabling Rights Act to guide you further, and so forth. And it goes on under Section 5.1 to show what may be seen as a copyright. Dancing, miming, karaoke must be capable of being performed and so forth. And artistic works, 5.1, computer programs, derivative works, and so forth, as clearly set out in Section 5.2. And of course, it says your work must be original. And the battle of copyright, I think we know quite a lot of court battles in the issues of copyright. I think I remember Aristoc Booklets case, which I know that bankrupted one of the infringers of new stylist bookshop or something. There was a prominent bookshop in Kampala, I think around the 90s and the early 2000s. It was a very popular bookshop, but all they did was the Ugandan way of doing things. They get the East African biology and they photocopy the whole thing and buy and sell. They do a word. So when they were taken on that and asked to pay quite a hefty sum of monies, they closed the shop and disappeared from town and so forth, which was of course a good thing because they simply are like, and you go to downtown, many shops I don't know whether to call them bookshops, but many shops selling books have photocopied books, material, a lot of even academic material, a simple photocopy buying, and they do not respect the issue of a copyright on that. So issues of infringement of such claims and defenses. So again, I go back to look at all the others. For patents, you look at the provisions under Section 92. And then the defenses that are available, you find Section 93, and a person will be sued for an alleged infringement of a patent may challenge the validity of the patent on ground that it should be revoked. And so if you're counsel for the defendant, you must be well equipped with an understanding of the patent and why you think it should be revoked, and you rush to court before probably they sue you. And then, or when they sue you, you raise that as your defense. The other defenses under sections 43 and 44 within the Industrial Properties Act, you can argue that the act was done privately, not for commercial use. I don't know how much you can defend that and so forth. If you're going into a violation of a copyright and you're found publicly, and then you begin arguing the private and not the commercial use, then the acts done in pursuance of scientific research, of course, we all know that that is available. Probably issues of security, that the use of the products on foreign aircraft, vehicle, vessel, or other countries accidentally entered Uganda. You see, one time I had to deal with a client who entered into Uganda with goods, I think, destined to Congo, Southern Sudan, and something, and there were a lot of goods worth a lot of money, but they went somewhere to offload and so forth. So when those issues were raised, they said, no, these goods are not for Uganda. They were just accidentally opened. And so you see, the defense is available. So it's one of the defenses that can be thrown in around. Or that you have a consent from the owner and so forth. You sometimes when counsel is desperate, you can even try to argue that the act was done in good faith and so forth. If we had a gentleman from Masaka producing Covidex at that time, you remember Covidex was so much on demand. Somebody in Masaka started he heard about the Luganda name. I forget the Luganda name that was part of the composition of Covidex. He started producing a lot of it and bottling the same way. Like when we picked him, he said, I was only trying to save life. That is all I was. It was done in good faith. And of course, infringement of trademarks, again, you look at the provisions of the law. And we have some authorities like Justice Bamine's decision on the Anglo fabrics and so forth, and defines that and tries to get into a bit of detail onto the infringements of trademarks, especially passing off unregistered trademarks and so forth, as per Section 35 of the Act, and Section 1.1, which defines it as falsely representing one's own product as that of another in attempt to deceive potential buyers and so forth. Again, the defenses for trademarks is probably concurrent use of the mark. If it is not owned by one, you can argue and say there's a concurrent use of the mark. It's by more than one person and so forth. If it fits within your situation and so forth. The other defense available is that you also license and assign. And again, I have been confronted by that kind of scenario at the commercial court. I had a client who went to France, bought again, I think, ladies' hair products and so forth. But then she was given an exclusive agreement and the right to defend the mark and everything in the country. When she came here and found another person importing it in larger quantities that she was even importing, said, please, can we go to the commercial code? We went to the commercial code, and the other person produces also a license and assignment from the same company in France. And the other one had even gone further. She had a license for Tanzania, Kenya, and so forth. We had to coil and put our tails behind and say, okay, I think this is a defense. How do we go back to the assigner and the licensor of the mark and say what you did was wrong? You can't do that. And then, but that is a brutality of the business world. And sometimes for copyright infringements and so forth, the act under section 46 defines when it may occur and so forth, and defenses available under section 15 that for instance, Chameleon comes making about his music, you say, I was only playing it for private use and so forth. I'm not selling it and so forth. Use of quotations or references, for instance, as still for teaching purposes, academic, educational purposes, and so forth, or written reporting on current events and so forth. So those are some of the exceptions and the arguments you can raise and so forth. Or public location for portraits and an image, public speeches and addresses. So but of course that you must recognize the owner and be able to credit the owner for you to benefit from that. The last part, like I'd said earlier on, was expert witness and technical evidence, intellectual property. My reading seems to only drag me to section 99 of the Industrial Properties Act, that the court may appoint any person with expert knowledge to assist court in any case where it appears that the court that such knowledge is required for proper determination of the case and so forth. So of course the general rules on expert evidence and so forth apply. The section simply allows court to call an expert witness. It doesn't go beyond that to say, this is how you do, this is the extent to which, and so forth. But like I said earlier on, personally, I have had to go for the experts, especially when we're faced with this Canada Care thing. Uganda Bureau of Standards was very handy and helped in that. The act and for the trademarks and the copyright, the law is silent on that. So I think the ordinary rules on expert witness and expert evidence may come into play and so forth. What remedies and so forth available under patents, damages again and so forth, compensation and declaratory orders under section 94 and so forth. The trademarks, injunctions and available, and I think in the Allied Britannia Allied Industries and Aya Biscuits, where we have had such kind of a battle, court issued an injunction against the infringement and so forth. Damages section 79 of the Trademarks Act. The Authority of Standard Signs, Uganda Limited, Fredley or Guang Trading as Standard Signs and another. Civil suit number 24-206. Court granted damages against the defendants infringing on the plaintiff's trademark and so forth. So we have had a bit of legislation in this country in respect of that, and they provide remedies. There's also a delivery of infringed goods for destruction as a section, I think 79.2 of the Act, and as it was ordered in the Vision Impex Limited versus Sans Ambrose case and so forth. The law also allows for removal of a trademark within the section 45, or you may be called to account and said, how much have you earned and benefited from the use of the mark and so forth? Can you account and for what? For copyright damages are usually like our prominent musician Angela Katatumba and the Anti-Corruption Coalition case, civil suit number 307 of 2011. It was found that the defendants had infringed on the copyright of the plaintiffs, and the court granted the plaintiffs 130 million in damages for infringement of an order to account. You can rely on the case of John Murray, Publishers, and G.W. Sekandi is a 1997 authority. And for injunctions, we have Stella Tai versus Anna Bez Kirata civil suit 967 of 04. Deliver and destruction, Copyright Neighboring Rights Act, again the Atai case. Courts can also order for inspection and removal of the infringing material from the premises by way of another pillar order, Section 54 of the Copyright Act, Copyright and Neighboring Rights Act, and so forth. And that has come into life in our courts in the case of Uganda Performing Rights Society versus Fred Mukibera, license application number 818 of 203. And so for their court granted an order to impound and destroy the infringing tapes of Chance Nalvega produced by the defendant, and so forth. Of course, the law also has some criminal sanctions. Like I said earlier on, in the Canada Care matter, actually, we ended up at Holy Kampala and I had to pick so many people to cool down the infringement and so forth. So the law has a provision for criminal actions and so forth. So basically, that is just an overview of what litigation in the area of intellectual property is. I may not have done enough justice to this, but I am sure I'm tickled your minds to be able to do your own research and add on to that and so forth. Thank you very much for listening to me, and have a great evening.
For those of you who are still online, thank you very much for holding on and listening to this beautiful, well-prepared, well-researched presentation on intellectual property. Richard Omongole, we are grateful. We can tell when people have put in effort to upskill, remind, and for that, a big clap for those of you who are here. To Richard. Richard, I don't see any comments. I just see Lydia Namungoma clapping for you. I see Francis Dungu clapping for you. And all of them are just saying thank you very much. And we are grateful from Uganda Law Society and the Secretariat. Have a nice day. Thank you very much. And this brings us to the end of the 2-day litigation training, 2024 version. Thank you for those of you who have come to join us. Thank you those of you who have been virtual, online. Thank you to our presenters. A big hand to the presenters. The feedback we are getting of the presentations have been first class. And we are grateful to you, the presenters. Some of you, we came to you very late, but you heeded our call to make sure that the 2024 version of the litigation training is worth it. Myself, as the convener, I would like to thank all of you for joining us for this version. We hope you've benefited. We hope you've got value for money. And my thanks go to, and I would like to now invite Godwin Matsiko. Can you come up and say a few words? Godwin, I don't want to take all the credit, and that's why I'm inviting him up here. Godwin, come. Godwin has been very helpful to me while we were preparing for this training. Thank you very much, Godwin. I want to thank you in the presence of everybody online and in the room. Thank you very much. And I would like you to make a few comments and then invite your ED so that she can close the training. I've done my part.
Thank you, Senior Counsel. And thank you again to the presenters, the people who have attended physically here at Fairway, and those who have been online for an impactful 2-day training. With your support, we hope to do more of these and even make them better. Yeah, so I don't have much more to say, rather than invite our acting CEO, Madam Meba, to come and close the session.
Thank you, Godwin. Protocol observed. Ladies and gentlemen, good evening to you all. I would like to start by thanking the ULS Council with the leadership of our President, Mr. Bernard Oundo. I also want to thank our convener, Senior Counsel James Sebugenyi, for having passion for ULS and also hosting this timely and important training. On the same note, I wish to thank the CLE committee together with the professional development department headed by Mr. Masiko Godwin. Thank you so much. To our dear panelists, thank you so much for generously sharing wide experience and knowledge through the topics selected and the insights from the training. You've really made a lot of research. We thank you for that. Your insights have enriched us, and I know it will contribute to our professional growth. Of late, ADR has taken sufficient space in the justice sector, but still litigation remains the heartbeat of our legal practice. It therefore requires commitment, reflection, and attention. To our dear participants, both physical and online, I want to thank you for attending and actively participating during the sessions. And it's my humble request that the lessons learned from the trainings, we take them seriously to help us in our growth professionally, and let's continue upholding the highest standards of professionalism. I want to thank all of us for generously contributing to this training. It has been a success. I thank you all, and I declare this training closed. Thank you.
For those in the room, we have tea at the back, so please make sure you